Russell Silverstein is a criminal defense lawyer. He's worked on cases similar. Now, two best friends convicted here, each pointing the finger at each other. How did that affect this case and this verdict?
It's difficult when you're defending somebody and you don't get the support that you need from the co-accused. When two co-accused point the finger at each other, we call it a cutthroat defense. It generally ends badly. It's hard enough to sell your client's story to a jury when it's being challenged by the co-accused and the co-accused is saying something different. All too often the jury says, you know what, we just don't buy any of it. They turn to the defense, the Crown evidence, and they very often convict of the most serious count on the indictment.
Yeah, those two different versions obviously not helping them. Also in this case that made it difficult, no weapon here, no apparent motive other than maybe a thrill killing, yet the Crown was still able to get the best possible outcome, first degree for the Bosma family. How challenging was this given this evidence and lack thereof?
Well, the Crown theory at first struck me as a little bizarre. The idea that two men would plan for months to kill someone while stealing his car, I didn't understand it at first. If you want a car, then buy one or steal one.
Because Millard sure could afford one.
Sure, but the idea of killing somebody simply to get the car, and it didn't make sense, and I didn't hear the Crown articulating this sort of thrill kill notion. That having been said, so many steps were taken prior to the commission of the crime that the Crown was able to point to that, plus all the intricate steps taken after the fact, as evidence of planning and deliberation. It was a difficult case for the prosecution, I think, in many ways, and very difficult for the accused as well.
And they both got first degree, and showing that it didn't matter to the jury who pulled the trigger here.
Well, it would have mattered to them in coming to the conclusion they came to, because it was possible for them to conclude that the person who didn't pull the trigger wasn't guilty of murder. But here, they clearly concluded that both of these men planned this murder together, and once you make that decision and they help each other, it doesn't matter at that point who pulls the trigger. That's quite right.
Smitch's lawyer says he plans to appeal. You've been following this case. Any grounds you can see here just from observing?
I don't know the case well enough to point to possible grounds of appeal, but I can tell you that in a case as complicated as this and as long as this, the instructions to the jury will be studied by the appeal lawyers with great care, and they will try to find errors made by the trial judge in the instructions to the jury. I'm sure they'll come up with something, and maybe errors in decisions made as to admissibility of evidence. We'll see how the appeal turns out, whether they get funding from the government to hire lawyers for their appeal. Either way, both of these men will one day end up in front of 3 judges of the Court of Appeal who will examine this conviction.
Always appreciate your insights, Russell.
You're welcome.